Well, this is number 7 of our series of lectures on litigation, and in this particular one we're getting more into, find a better pen, motion practice. Okay, so what do we mean by motion practice? Well, I kind of touched on that in the last lecture when I talked about the 12b6 motion to dismiss. There's several different motions, and you know, most of these are driven by different rules. 56, for example, is what we call summary judgment. This one is dismissal. You can have different discovery motions. There can be motions up in the 30s relating to frivolous complaint, failure to comply with discovery. You know, these are all possibilities. So in other words, you're bringing the complaint in the form of a motion against another party because they failed to do what they're supposed to do. Well, let me say that in the early going, what you want to do is get a hold of those civil rules, both state and federal, and look at them in the context of the big thing we're going to be looking at least in the early going of this area, is discovery. Okay, so what do we mean by discovery? Well, it used to be that everything that was done in the law was done by what we call ambush. In other words, you didn't know what the other person had. You didn't know what their witnesses were going to say. And so there's a lot of different forms of discovery now. And discovery means that the idea, what the courts want, is they want both parties to be on equal footing. Both lawyers know what the other lawyer knows within certainty to a certain point. No surprise witnesses like Perry Mason. Do you see the man in the courtroom that murdered your husband? Yes, he's sitting on the back row. You know, that happened to me. Believe it or not, one time I had a guy of what we call strong-armed robbery. He was accused of robbing a little old lady, and the little old lady's up on the stand, and they said, do you see the man in the courtroom that stole your purse? Yes, he's sitting on the back row. My client and I were sitting on the front row. So, you know, basically the prosecutor said, rut row, you know, just a little kind of a joke there. But I immediately jumped up and said, Judge, I move that the bailiff take that man into custody. And the judge said, so ordered. And the bailiff goes back, grabs the guy. Here it's my client's first cousin was the actual robber, and it was a mistaken identity case. We solved it right in the courtroom. But that never happens, honestly, folks. You know, I've been at this for 30 years, one way or another, and that happened to me one time. So basically, you know, you're not going to see that very likely. And so basically, when we're looking at discovery then, the idea is to try to get as close as you can to put both parties on the same footing as far as their knowledge of the facts of the case. So what are some of the ways that we have for motions? Well, first of all, there's a Rule 7 requirement, and it says that the motions need to be in writing, okay, which only makes sense. And it needs to be stated, basically I'm going to use the word clearly. It says with particularity, but I'm going to say it's got to be clear what you're asking for, and then there needs to be a request for relief at the end. So you've got to explain yourself, state it clearly, and then you've got to write it out. These oral motions in the courtroom, they're kind of dying out. Here again, oral motions, kind of like ambush. So basically no ambushes, okay? You know, that's where the guy sits up in the hills with his rifle and shoots the cowboy when he's riding down the trail. You know, we don't want that in the law anymore as a civilized society. So basically, the motion format in writing needs to be similar to the caption in the complaint. So basically, be consistent. You start out, you put those right parents in there, then put the right parents in your motion. If it's clear in there, there's no lines or anything in there, always be clear. Well, the next thing is notice. So you need to put each side on notice. If you've got a motion regarding the other side, you need to serve them with a copy. I've actually seen cases where attorneys only serve the judge. They didn't even serve the opposing attorney. And here again, it kind of goes back to ambush. It goes back to ex parte. This all relates to due process, okay? Even in civil court, due process. Okay, everybody has a right to an understanding of what the hearing's about, what's going on, and so basically they need to be filed with the court and served on the opposing party. Okay, so these are important basic prerequisites to any kind of a motion. Okay. Proof of service, a lot of times you don't really need like a sheriff to serve these. That's a basic thing. But you might need, for example, an affidavit that says forth that yes, I did serve the people. A lot of times it's just a certificate by the attorney for one side that he served the other attorney. Here again, these checklists are good. You ought to look at developing a checklist. Did you do everything that I mentioned in doing this correctly? And then, of course, if there is a motion, there needs to be a response to the motion. And if there is not a response, then there can be sanctions, okay? Sanctions for failure to respond, okay? So, and that can be fines. It can be attorney fees. It can be, if there's a good reason, it can be just an extension, or in the worst case for plaintiff, it's kind of like the death penalty for your case, and that is dismissal with prejudice, okay? Dismissal with prejudice, meaning you cannot refile that lawsuit, okay? So all these motions, you always need to respond, or there could be sanctions. So that's pretty important. We'll get more into the discovery side of it, like we told you. We'll also, most of the time when you have a motion and a response, court may call for argument, and then at some point the court will prepare an order. Now, a lot of times when I say the court will prepare, the prevailing party a lot of times will prepare that order. So prevailing party prepares the order, judge signs it, and then it's distributed, okay? Sometimes people file motions and they actually include the order that they want, and sometimes if it's something simple, the judge will just sign it. There won't be any argument, no discussion, nothing. They just wait for the response and they sign the order. So, that's one of the things to consider. Well, this is a rather short comment that we have here today in this lecture. Some of them are just going to be like that. But we want you to, study this. Here again, if you've got motions, folks out there that have done this kind of work, share some of those. Of course, you don't want to name parties and stuff like that, but just the format's what we're looking for. So if you could put some of these up as attachments in the discussion, it would be fun, I think, to compare notes on what different counties do. And it might be a good guide for some of the less experienced students, and it would be a big help to me. My main thing is curiosity to see what different counties do. Some of you might work more in the federal system, for example. You could share that. And so, it'd just be fun if we put up, some copies of complaints we've done, answers we've done, strike out names, or, just delete names. Let's see what we got out there. What's going on out there in the form of the different forms of motions, complaints, and answers. Okay, so basically that's it for this time. This is item 7, lecture 7. We'll be back with lecture 8 soon. So if you have any questions, problems, always feel free to get a hold of me. Phone numbers in the syllabus. Communication, click on communication, see the little mailbox, send mail, instructor, send me an email. Okay, thank you, and we'll be back in touch.